at Leo Lawyers. Although this looks and sounds like me, what you're watching is my AI avatar, presenting from a script that I've written and approved. When most people heard about the federal court's decision against Kohl's and its down promotion, they probably thought it was just another supermarket pricing case. But in my view, the Kohl's decision is about something much bigger. It highlights a growing trend in Australian consumer law enforcement, where regulators are no longer just looking at individual advertisements or isolated statements. They're increasingly examining the systems, processes, pricing models, and business practices that shape the customer experience. And that's something every Australian business should pay attention to. The case arose from proceedings brought by the Australian Competition and Consumer Commission, or ACCC. The ACCC alleged that Kohl's had engaged in misleading conduct through aspects of its down promotional campaign. On May 14th, 2026, the federal court found that in certain instances, product prices had been increased before later being reduced and promoted as discounted. The court accepted that this could create the impression that consumers were receiving a genuine saving when that was not necessarily the case. Because the products involved were everyday grocery items, the decision attracted significant public attention. The legal significance extends far beyond supermarkets. One of the most important lessons from recent ACCC enforcement activity is that regulators are increasingly looking beyond individual statements. They're asking broader questions. How does the pricing system operate? How are discounts calculated? What information is presented to consumers? Could the overall process create a misleading impression? This is particularly relevant in an era where businesses rely heavily on technology, pricing algorithms, automated promotions, subscription models, website content, online sales funnels, comparison tools, customer communications, and AI-driven marketing systems can all create legal risk if they generate expectations that aren't ultimately met. Importantly, this isn't just an issue for large corporations. These same principles apply to small businesses, startups, professional service firms, builders, developers, and online retailers. The Kohl's proceedings are not occurring in isolation. In recent years, the ACCC has pursued major matters involving companies such as Qantas, Optus, and Volkswagen. The facts in those cases were very different, but they share a common theme. The regulator is increasingly focused on conduct that affects large numbers of consumers and on business systems that may create widespread consumer harm. What businesses should take away from this is that the legal principles being applied are the same principles that govern every business operating in Australia. Consumer law doesn't only apply to large corporations, it applies to everyone. Historically, many businesses viewed consumer law compliance as something for the marketing department. Today, that's no longer enough. Pricing practices, advertising campaigns, website content, customer communications, subscription structures, and sales processes can all create legal exposure. As a result, consumer law compliance is increasingly becoming a governance issue. Businesses should be considering these risks before a campaign launches, not after a complaint is received. The reality is that a preventative legal review is often far less expensive than responding to an ACCC investigation, defending litigation, or managing the reputational damage that can follow. The real lesson from the Kohl's decision isn't about supermarkets. It's about the increasing regulatory focus on how businesses interact with consumers and whether their systems create misleading impressions. Businesses of every size should review their consumer-facing practices, including pricing models, promotional campaigns, online content, and customer communications, because when regulators assess compliance, they are increasingly looking at the entire system, not just a single statement. Consumer law risk continues to evolve, and businesses need to evolve with it. The Kohl's decision serves as a reminder that even ordinary business processes can attract significant regulatory scrutiny if they create misleading expectations for consumers. At Leo Lawyers, we assist businesses with consumer law compliance, advertising reviews, marketing practices, regulatory risk management, and ACCC-related issues. If you'd like tailored legal advice, you'll find our contact details in the description box, or you can visit us directly at leolawyers.com.au. Thank you for watching.